Thank you very much. So, yes, I have the pleasure today of chairing the session entitled Health Regulation, Science in Court and Other Protection Mechanisms. Are consumers misled and left in the cold? And I want to start off with this very interesting statue here. You'll note that it's the thinker, obviously, but the reason he's got his head in his hands like that is because of the situation that we are faced with regarding health supplements and complementary medicines and their regulations. So this problem's obviously been around for a very, very, very long time. Okay, so let me introduce the speakers on my panel today. Firstly, it's myself. I've already been introduced, so I don't need to say much more than that at this stage. Then we have Dr. Harris Steinman, who is a medical practitioner, a consumer activist, a health scientist, and a lecturer at the University of Cape Town and Stellenbosch, so that's okay. He is the founder, editor, and publisher of CamCheck, a South African consumer's guide to scams, pseudoscience, and voodoo science. There you go. He has been at the forefront of countering bogus advertising health claims in the media, and I can vouch for that. Then we have Roy Jobson, who's also a qualified medical doctor at the University of Cape Town and subsequently specialized in family medicine and clinical pharmacology. He was awarded a Hubert H. Humphrey Fellowship in 1992 to 93, assigned to the University of Minnesota. Jobson was a council member of the Medicines Control Council, MCC, from 2002 to 2008, and inaugural chairperson of the MCC's Pharmacovigilance Committee. He's an associate of the College of Clinical Pharmacologists of the Colleges of Medicine, South Africa, was an associate professor of pharmacology, Faculty of Pharmacy, and since 2014 he's associate professor of clinical pharmacology, School of Medicine, Sefako Makato Health Sciences University. So, very eminent panel. They will be addressing, obviously, examples of the issues which I'll be raising from more of a legal perspective today. So, without any further ado, let's get on with it. So, let's first of all start off with what is pseudoscience, and I thought some dictionary definitions might be quite useful. So pseudoscience is a collection of beliefs or practices mistakenly regarded as being based on scientific method. And any of you that have read articles in the press which purport to be scientific will immediately recognize this definition. And then at the bottom we have, what is a quack? Because if we're talking about quackery, we need to understand what a quack is when it's got nothing to do with a duck. And it's a person who dishonestly claims to have special knowledge and skill in some field, typically medicine. So you can get quacks other than doctors, by the way, as you can see from the definition. I think what's interesting is that even great thinkers such as Carl Sagan had something to say about this field. He said, I worry that, especially as the millennium edges nearer, pseudoscience and superstition will seem year by year more tempting. The siren song of unreason more sonorous and attractive. And of course he's right. As one looks now, we're now already in that millennium, you start seeing more and more of this belief in these pseudoscientific type of things, the so-called complementary medicines, which in many cases are nothing of the sort. So let's talk about what is the regulatory environment that we find ourselves in when we're talking about protecting consumers against pseudoscience and quackery. I'll start off with the Medicines and Related Substances Act, which has an interesting definition of medicine. Whereas many people might think that a medicine will be defined by the fact that it contains some or other medicinal compound by definition. In fact, that is not true. And you can be a medicine by purporting to be suitable for use or manufactured or sold for use in diagnosis, treatment, mitigation, modification, etc., etc. So you can be a medicine even though you contain no medicinal substance at all. A bottle of water which would claim to do one of these things, to treat some other condition or mitigate or modify or prevent a disease, would be considered a medicine under our law. So when you see many of these products on sale, bear this in mind. It doesn't matter what's in there as much as what are they saying that it does. And since you are a medicine, you therefore have to be registered. And the Medicines and Related Substances Act provides that you have to register a medicine, and it says, if after consideration of any such application, and after any investigation or inquiry which it may consider necessary, the authority is satisfied that the medicine, medical device, or IVD in question is suitable for the purpose for which it is intended. So you're stating what the purpose is on your packaging. If you want to get registration, you have to show efficacy for that purpose. It complies with prescribed requirements, and it's safe, efficacious, and of good quality. So those are the legal requirements for any product which is sold claiming to be a medicine. Be it a complementary medicine, being it a health supplement of some sort. For that matter of fact, it may even apply to certain foodstuffs depending on what it says on the packaging. And then it says under the labeling and advertising requirements for these types of products that if you sell such a medicine or a scheduled substance, but scheduled substances by definition would be considered to be medicinal because of the nature of the product rather than what is said about it, then you need to have a label which has specific particulars on it, and I'll get to those particulars in the next slide. It then also provides in this law for this marketing of medicines regulation, which says the minister shall, after consultation with relevant industries and other stakeholders, make regulations relating to marketing of medicines, medical devices, or IVDs, and such regulations shall provide for codes of practice for relevant industries. Now, up to now, there hasn't been such a code of practice, but I'll show you in a slide coming up, there is such a process on the go at the moment. So, are you a medicine or are you a food? And it's quite simple. One has to classify these things. You have a medicine and a foodstuff. You are the one or the other. If you can put it in your mouth and it's edible, it can't be something else. It's got to be one of these two. And a complementary medicine is a medicine. There was this mistaken belief for many years in the health products industry that somehow there were three categories: medicine, complementary medicine, and foodstuff. You'll note I say mistaken belief. It's medicine, and complementary medicine is a medicine like any other medicine. When I talk about the regulations now, you'll see what I mean. Let's quickly cover the Foodstuffs angle. So under the Foodstuffs Act, it says no health claims may be made on packaging or in advertising of foodstuffs. So immediately it eliminates the whole problem of is it a foodstuff or is it a medicine? If it contains medicinal claims, it's a medicine. Doesn't matter if it's you would consider it a foodstuff if it was simply unwrapped or didn't have any claims on it. No functional claims may be made on foodstuffs. Enforcement, however, is currently not really taking place, especially on locally produced products. So if you produce it locally, there's no inspection that takes place. Imports, however, do get inspected largely by Port Health, and they have periodically stopped imports with claims made on packaging. So foodstuffs, not that well regulated. However, no claims are allowed on foodstuffs as we sit here at the moment. There might be changes coming in the future which would complicate things, but at present, no health claims are allowed on foodstuffs. But let's talk about the medicines leg of my classification system. So, what are the recent changes? We've got the South African Health Products Registration Authority has replaced the Medicines Control Council as of very recently. There's a new supplement definition and a complementary medicines definitions as from 25 August 2017, so just very recently they passed new regulations that deal with supplements. And as I say, they define a health supplement now, and they have medicinal classifications for complementary medicines and supplements. No, okay. Use the button on the keyboard and all those fellows. All right, so they have a definition of a complementary medicine, and basically what it says, if it's made from anything on earth, I would suppose, because it's a plant, fungi, algae, seaweed, lichen, mineral, animal, or any other substance. I don't think that leaves anything. I think if it's made of anything, it could be a complementary medicine. But most importantly is the red, is used or purported to be suitable or used for manufactured or sold for use in, and then they have the things that it can be used for. So it's again a similar definition to what a medicine was. And then very importantly at the bottom, it talks about as a health supplement or in accordance with those disciplines as determined by the authority. So there are various Ayurvedic and those types of disciplines. If it's purported to be used for any of those things, it becomes a complementary medicine under the medicines regulations. And they've done away with this strange separation of complementary medicines from normal medicines. There are simply now the medicines regulations, and this falls in with all other medicines, just have their own classifications. There's a definition of a health supplement, and a health supplement, it talks about it's an extract or mixture of substances as defined by the authority, sold in dosage forms, used or purported again for use in restoring, correcting or modifying any physical or mental state by complementing health, supplementing the diet or nutritional effect. But of course it excludes anything which is an actual medicine, which does the same things. Funny enough, they introduced this concept of a dosage form, so it would need to be sold in a dosage form as opposed to be a capsule, a sachet. So there could still be some products which might not be considered a health supplement because they're not in a dosage form. The classification of complementary medicines, they've created a separate classification category D, and there we're talking about discipline-specific medicines with such disciplines determined by the authority. Again, the health supplements fall under this, but the key thing here is that they've simply created a further category of medicine. These things are now medicines, and they must comply with medicines regulations. So what do the medicines regulations say? Well, there's specific labeling requirements. You would need to state that it's a complementary medicine. You need to state, for example, if it's a health supplement, if it is a health supplement. If it's not registered with the authority at the moment, then you would need to state it's an unregistered medicine, not an unregistered something else. It's an unregistered medicine that has not been evaluated by SAHPRA for its quality, safety, or intended use. And then, interestingly enough, there's a GMO provision for all the GMO or anti-GMO people. If it contains at least 5% of modified organisms, the following warning shall be on the packaging: contains genetically modified organisms. Now, those of you who don't know, a lot of these products contain cornstarch. Cornstarch is highly likely to be GMO. So your health supplements are now going to carry a GMO warning. Good luck selling them. Then we have further provisions regarding if you also include a scheduled substance, but more importantly, you need to include information like the proprietary name of the medicine, its registration number, the expression that it's registered under this particular law, what category it falls under, the dosage form of the medicine. Here's some very important information, because you now need to have an ingredient listing on complementary medicines and on health supplements. You need the approved name of each ingredient and the quantity thereof contained in a dosage unit or per suitable mass or volume unit, ranked according to the active ingredients with the highest schedule in lettering which has minimum legibility, and it goes on there. Then you need the name and percentage of any bacteriostatic or bactericidal agent, the approved name of any antioxidant which is added, and if you add coloring. So they want a lot of information on the packaging. The public can now see what is actually in this product that is making these claims. And in many cases, I think the public will be very surprised what is in some of these products. And then these full requirements I've just mentioned apply to the outer packaging, so it can't be hidden inside somewhere in a leaflet. When I walk into a discount and I look at the product, I must be able to see this information before I buy it and take it home. What will be the point of only finding out when I get home? I need to know what it is before I decide to buy it. It's got to be on the outer packaging. Oh, sorry, very importantly, no gratuitous marketing information is allowed on packaging. So you can't have a lot of spiel on the outside about what it's going to do and all sorts of unsubstantiated claims unless they are part of the registration process. So this regulation is already in effect. It came in effect in August 2017. Perhaps somebody could have challenged it. I'm unaware of anybody challenging this regulation in a court. Currently, there isn't any enforcement that I'm aware of, but one should remember that the Medicines Control Council already regulates and inspects ethical medicines, or normal, let's call them prescription medicines and over-the-counter medicines. There's absolutely no reason that they shouldn't follow the same procedures for complementary medicines and health supplements. And for example, the Medicines Control Council already published a notice warning of action against unregistered products. So they're on the ball with this. Okay, moving on from the Medicines and Related Substances Act to Advertising Standards Authority, which I think Dr. Steinman will talk about it to some degree after, with examples. But very importantly, it was established as a self-regulatory body. They have a code of practice. But they require independent prior scientific substantiation of claims. So if you have a product and it's making unsubstantiated claims, you cannot only, when challenged, suddenly start trying to put your substantiation dossier together. According to the ASA code, you have to have all of that available before you make the claim. And of course, it's got to be independent, scientific, it's got to be acceptable to the ASA code, to the ASA. Recently, there have been several court cases between the ASA and various players in the CAMS industry. In some instances, the court found against the ASA, but in the last couple of weeks, the Supreme Court of Appeal in Bloemfontein ruled mainly in favor of the Advertising Standards Authority on the following basis. They said, first of all, the ASA cannot take direct action against non-members. So many complementary medicines companies say, well, we're not members, so we don't have to worry about this. However, the Supreme Court of Appeal went on and said that the court can consider complaints against non-members and then order its members not to run the ads of non-members. So they cannot act directly against non-members. Obviously, if they can't advertise or sell their products, it's pretty much the same as acting against them. And this was a matter against Herbex, so accordingly one should presume that ASA now has jurisdiction over foods, complementary medicines, and supplements, because this was the field that that particular litigation was in. In terms of the ASA complaint process, consumers can complain free of charge, competitors would have to pay to complain, there's a possibility of appeal. It's quite a long process though, and it's not a push-button, instant coffee type of situation where things will just stop. The Herbex case must have run 5 years before it finally came to a conclusion in the Supreme Court of Appeal. As I said, it's free to a consumer. It's much simpler than going to court, but yet it still takes quite some time. The ASA can only consider matters which are provided for in its own code, and very importantly, the ASA cannot consider complaints that somebody is not complying with the law. The ASA is not a legal body. They're a code-driven body. They have their own code. One risk of the ASA is that they have a non-scientific panel members which could be bamboozled by pseudoscience. And we've seen this, is that they don't understand what's being said. They're being bombarded from two sides by experts or so-called experts with reams of paper, each one claiming the other is wrong. And I'm not sure if they go to the back and toss a coin or how they decide who they're going to believe, because they have no scientific basis for understanding who's right, who's wrong. But what is interesting, there's another body that's coming into play, and that's called the Marketing Code Authority, the MCA. So the MCA is taking up where the ASA has left off, and they are trying to pick up on the Section 18C of the Medicines and Related Substances Act, which provides for a code of practice under the MRS Act. And what's very important is if the marketing code gets the Ministry of Health to accredit them under this section of the Act, then rulings by the Marketing Code Authority would in fact be in terms of the MRS Act. So this is a very promising development. We then have the Consumer Protection Act. Now the Consumer Protection Act, again, one would assume this is the one that really should be protecting consumers. It provides for the right to information in plain and understandable language. It provides against false or misleading or deceptive representations. For example, cures, remedies, weight loss, treatment of diabetes, things like this, which are unsubstantiated by real science, would in fact be contrary to the Consumer Protection Act. Product labeling and trade descriptions have to be accurate. You have to provide information on GM labeling. Question, of course, comes up, what about something like traditional medicines, which have been to some extent excluded from the Medicines and Related Substances Act regulations, but are not excluded from the Consumer Protection Act. Then there's a consumer's right to safe, good quality goods, and finally, there's a liability for damage caused by unsafe goods. And that's very important, because if I'm being sold these complementary medicines or health supplements, and they have some or other unexpected interaction with my medication, I have high blood pressure, I take something, this blocks my high blood pressure medication, I get a stroke. How does that play out? And here we've got liability arising under the Consumer Protection Act. So that's a very, very important piece of legislation to remember in this whole complementary medicines pseudoscience sphere. So under the Consumer Protection Act, a company could be fined up to 10% of gross turnover of their entire company if they're found guilty of contravening the Consumer Protection Act. The liability I spoke about is so-called no-fault liability, and it's the entire supply chain that in fact could be involved in the claim for liability. There's liability for hazardous or defective products. Defective we can understand, but some of these medicines which are based on pseudoscience or simply, I'd like Harris's one, voodoo science, may in fact be hazardous, and never mind just being non-effective. And then there's liability for insufficient instructions or harm caused due to failure to warn of harm that may occur. So the whole issue of side effects, progress of disease and so on, which could occur if somebody stopped taking the medication prescribed by their physician and started taking these complementary medicines in the belief that their condition will improve, and in fact it gets worse. There could be liability in terms of this as well. So, a final thought from Carl Sagan. Science arouses a soaring sense of wonder, but so does pseudoscience. Sparse and poor popularizations of science abandon ecological niches that pseudoscience properly fills. If it were widely understood that claims to knowledge require adequate evidence before they can be accepted, there would be no room for pseudoscience. And I think that is as true as when he said it. Thank you very much.